Hello and welcome to On the Stand with Ashish Arun, a podcast where we talk to attorneys and expert witnesses to decode the law, practice, and business of providing expert witness testimony in litigation. In each episode, we pick up a topic that is important for experts, recruiters, and attorneys and try to bring a new perspective, a fresh insight, and identify some key takeaways that can benefit everyone who is involved in this wonderful ecosystem.
My name is Ashish Arun, and I'm the CEO and founder of Xlightum, a company facilitating interactions between experts and attorneys. I'm also the CEO of Expert Witness Profiler, a legal data and information company that helps attorneys use court data in deciding how to work with their own and opposing experts. Now, expert witnesses, they've been very curious, and I say this because I have seen it in my interactions on forums and social media, as to how attorneys review them and their profiles when they're looking to retain an expert for their next case. So while expert directories, search firms, and maybe some marketing pundits, they'll tell you that they can read an attorney's mind, the fact of the matter is that there's no substitute for the insights that a litigator has, someone who is retaining, opposing, deposing, and challenging expert witnesses day in and day out. So with that in mind, we thought, why not ask someone who really knows this stuff and bring their insights to our community of experts. So it gives me immense pleasure to present to you today's guest and speaker, Jordan Redavid, ESQ. Jordan is a founding partner at FIscher Redavid Trial Lawyers with offices and practice in Florida, Georgia, and the US Virgin Islands. The firm has secured multiple notable victories for their clients, including an $11.9 million settlement for a pre-trial detainee in a county jail who was the victim of medical negligence. In another landmark trial that garnered global attention, they successfully prevailed against corporate giants McDonald's and Upchurch Foods. In today's webinar, Jordan will provide invaluable guidance on how plaintiff attorneys select, prepare, and present expert witnesses. He'll share best practices gleaned from his many years of experience using expert testimony to win tough cases. The webinar will cover finding the right experts, effectively preparing them for deposition and trial, and delivering impactful direct examination, and more. So on that note, let's welcome Jordan Redavid, ESQ. Jordan, welcome to the webinar.
Ashish, thank you for having me. That's a really nice introduction. Big shoes to fill. Hope I can fill them. But I want to say that I echo all the same sentiments that you just shared with the audience. As a very practical matter, yes, I practice law, personal injury law for plaintiffs in the U.S., specifically in Florida and Georgia, and our firm has offices in the USVI and attorneys there. But what I'm really doing is I'm trying to help people who are wronged, sometimes family members who have lost a loved one, get the full benefit of what our justice system in America can offer. And in our civil courts, that's money. But even as a lawyer, someone who's familiar enough with the laws, statutes, regulations, common law, case law, etc., I am unable to actually perform my job without the role of experts in almost every single case, because you need experts often for liability, you need experts to prove causation, and almost always you're going to need an expert to explain the extent of somebody's damages. And so when you presented this opportunity to me and somebody with your background and pedigree, I thought it was a really nice symbiotic relationship, and I'm excited to dive into the issues here.
Thanks a lot, Jordan. So why don't you begin with, by elaborating upon the importance of expert witnesses and their broad role, especially in personal injury and medical malpractice cases. Like, how important are experts and what type of experts are commonly used in these cases?
So I like to start these types of questions by reminding people that in most jurisdictions, there are standard or pattern jury instructions. And Florida is no exception. And one of the pattern jury instructions in Florida, so when I walk into a courtroom as a lawyer and there's jurors in the jury box, the judge will tell them multiple times throughout the case, what a lawyer says is not evidence. It's argument, it's opinions on what the evidence may have shown or will, but it is not in and of itself evidence. And so if I'm going to have any credibility as an advocate in the courtroom, when I discuss the evidence, I better be talking about something that's credible, believable, and persuasive. And in the context of expert witnesses, that's what they do. Experts are specialized, whether through knowledge, education, training, or experience, specialized people who come into a courtroom who can say, the resources have been made available to me to review the necessary records, to speak to the necessary people, read the necessary depositions, whatever it may be, or I've been to the scene of the accident, whatever it is. I've looked at it all, and I could tell you based on my knowledge, training, and experience, this is what it means. Here are my opinions, oftentimes within a reasonable degree of medical or nursing or engineering certainty, whatever their specialty is. And so it's through the experts. They're the real conduit to which I can convey to a jury something of substance. So as in all things in life, believability often comes down to credibility. And credibility with experts it's the number one, it's the alpha and the zeta. That's it. I don't care how educated somebody is. I don't care how long their resume is. I don't want to say I don't care, but I mean, like, it's very, very insignificant how many times they've been published. If they can't walk into a courtroom, sit in a chair, swear to tell the truth, and convincingly tell the truth in a very honest and forthright and an understandable way. So in my practice, when I say plaintiff personal injury work, that means a few different things. Yes, as a general rule, it means somebody's been injured or killed through the negligence of somebody else or another company. But what it really means is I need to first decide what type of case it is, because that right there will decide often how many experts I'm going to need. Here's a very clear example. If there's a car accident case and my client got rear-ended, I'm probably not going to need an expert on liability, meaning some kind of engineer to come in and say, I looked at both vehicles, I checked out the fenders, the damage, and all of it through physics. I can tell how fast. I don't care. It's so straightforward. If I just show the jury the picture and the client says what happened, I was sitting at a light, I got rear-ended, I don't need an expert for liability. Whereas another very silly but common example is somebody slips in the rain. Let's say they just left the grocery store and they slip on the concrete right before they walk out to their car. Well, now the question becomes, was it just a freak accident that happened, or was the store responsible because they failed to use reasonable care, maybe in selecting the right vendor to install the concrete, or to make sure that it was, slip resistant, that it had sufficient friction between footwear? You start getting into the weeds, and now you realize, hey, if it's a slip and fall case, I might need a liability expert, somebody who can come out, test the scene, and explain based on the materials that are used, whatever. And obviously, in medical malpractice cases, it's imperative to have a liability expert, because doctors, nurses, and rightfully so, they are revered professionals across the world. And so if you are going to bring a claim against them, jurors are already predisposed and biased in their favor, and it's totally fine. You know why? It's human nature. I might just as well be too. So what's interesting, and I think a lot of plaintiffs' lawyers take the wrong perspective here, is Florida is one of the jurisdictions that requires plaintiffs or claimants at this point, they haven't filed a suit yet, but if they want to bring a claim for medical negligence against almost every type of medical provider, they need to do a very thorough pre-suit process, which requires by law the use of experts to basically preview outside of the court, but to the potential defendant provider and their attorneys, I have a legitimate case here. So you have to secure an expert up front, meaning me as the plaintiff's lawyer. Somebody hires me, I must retain an expert in the same specialty or field. He or she has to review the available evidence and give me a preliminary affidavit and opinion. So just as a starting point, I think it's important to say there is no such thing as a case that comes into my hands as an attorney and I say, I won't need an expert. The question is just simply how many, and are they liability or damages, etc.
So that was really, useful, because it actually, even after spending so many years researching experts, it actually gave me new pointers on, how important experts are and what are the key factors that are helping you in selecting an expert. So let me ask you about the selection process. So at what point in the case do you decide that, okay, this is the time to contact an expert? And from there till choosing which expert to go with, what is the usual process in a case for you?
So when I was younger and didn't know any better, because sometimes the only way you can learn is by trial and error, I would wait too long into a case. So unless the law required it, I often wouldn't consult or retain an expert pre-suit. And then even in litigation, I would typically wait. So just for context, most jurisdictions that I practice in will issue a trial order, which is just another way of saying, here's a trial date. Now here's a bunch of deadlines preceding it, working backwards. One of those is a deadline to disclose expert witnesses. And I would often use that deadline as I don't have to worry about it until that gets close. A terrible mistake strategically. The earlier that I can involve experts, the better. In fact, if I can involve them in the screening process, meaning do I even want to go forward, or should this client even go forward? Let me give you a very real example that just happened. This is literally happened this week, and it's not the first time. I had a woman engage my firm's services, me in particular, in a potential medical malpractice case in Florida, dealt with a rotator cuff surgery in her right arm that she believed went awry. Now, when she came to me, this woman is orthopedically and neurologically devastated. Among other things, she's got very severe complex regional pain syndrome. Her right arm has basically gone from fully mobile and functional to useless and functionless. Catastrophic damages for a woman in her 50s. When she came to me, based on what she shared with me, and she's not a physician either, it just smacked from a common sense standpoint. Something must have gone wrong in this arthroscopic shoulder repair. I mean, like, how could it go from a small repair to you can't use your arm? I was excited to take the case. The younger me would have said, for sure, I have a case. Let's pursue it aggressively. The more seasoned and wise Jordan said, let me call somebody whose opinion I trust. So I went and I found a board-certified orthopedic surgeon who's licensed in New York, but who I know is a straight shooter. And I didn't shade anything. I said, this is what I know. I'm going to go secure all the records. I need you to review them and even tell me if you think there's a case here from a liability standpoint. He agreed. So we went out, we procured the records, 30, 40 days, whatever it was, we sent it to him. And yes, did it cost me a couple $1,000s to have him review them? Yeah, he's a professional. It's his time. But it saved me. The end of the story is he told me, even to his surprise, based on the operative report, the imaging studies and everything, this was just one of those rare occurrences where the patient fit into the statistical super minority of 1% or less, that based on that type of procedure, CRPS is going to manifest. There's nothing that the doctor did wrong. In fact, not just in the surgery, but even after, he was diligent, prompt with the follow-ups, etc. So now I have to deliver the bad news to the client, which is part of the job. But in 40 days, this woman got an answer. And now she's no longer going to be saddled with the stress of thinking this doctor she trusted did something wrong and ruined her life. She's still damaged. I still feel terrible for this woman. But even she thanked me because now she has the answer she needed. And I've saved, like as a professional, I've saved probably 2 years, And by the way, I got a second opinion just to make sure. But I'm just giving you context that your question was how early should you be involving them? And I think the sooner, the better. There's obviously an economic consideration here. I'm not suggesting to spend frivolously, but with the benefit of experience, you start to realize. And in that particular case, it's one of these, the ends will justify the means. If there is a case, the damages are so substantial that the investment of a few $1,000s up front is worth it. And if I have to eat it like I did in that case, so be it.
So in this case, it looked like you knew the expert. You knew which expert you wanted to go to and to have them review the case. But in case it's a type of injury where you don't have a go-to person or like a doctor who's you've not worked with. So what's your, do you have a go-to resource as to finding a new expert? Like, would you go for a referral or a directory or a search company? Like, what's your MO?
This is a solution that has yet to be solved for me. But I only think it's because each attorney is an individual, so we're all idiosyncratic. We have different preferences, how we like to query for things. But as a general matter, I don't think there's one singular resource that is so adequate that no others need to be consulted. And so to your point, I will often start by searching through TrialSmith-based forums. So like TLEL in Florida, which is an FJA platform, or GTLA, the Georgia Trial Lawyers Association, or those equivalents. They can be very meaningful resources, both contemporaneously, like posting something, this is the type of expert I think I need. Does anybody know someone? But also you can search historical archives. It's a good starting point, but I am always hesitant to rely exclusively on that because, again, even that resource is really just the collective benefit of other people's experience. And if they haven't had experience with potentially the preeminent expert out there, then I'll never find him or her. So on occasion, I have paid for and retained, sometimes in a subscription model, like a recurring ongoing basis, recruiting companies or search companies, headhunter, whatever they want to call themselves. But there's a few agencies out there that for a fee will do an intake of the case, kind of explain to you the types of experts you think they need, and they'll give you pre-screened, so to speak, pre-qualified. But even that, by the way, which I think the financial cost is a deterrent from using it, but even assuming they're the best, it's not a guarantee. And I actually have a very real life example, which is I had it was a complex case from a liability and causation standpoint, but I had basically what amounted to a birth defect case. It involved renal agenesis. So in utero, the fetus had what appeared to be 2 kidneys growing normally. Over time, one disappeared. That's what renal agenesis is. It's a rare thing to happen naturally. this baby happened to be in a woman who was pregnant, living in a rental property in North Florida that was riddled with mold, toxic mold from years and years of water intrusion, not just like naturally occurring. So I went to a company because it's a very unique claim. And there's not like somebody holding themselves out to be, hey, I'm a neonatal and maternal fetal medicine specialist in toxic mold exposure. I mean, it's a very niche thing. So I went out and I used one of those agencies, and I found someone who is on paper, and even just in speaking with him and reading his publications, has to be qualified, and was, in my opinion. Retained him. He did a great job on the case. This is not an indictment of him at all, but he got Dalberted and struck before trial, and it was catastrophic for the case. We ended up losing and getting summary judgment against us. And although I disagreed with the ruling and I appealed and all of that, tried to get all the way up to the Florida Supreme Court before striking out, even the recruiting agencies is what I'm trying to say. It's not a guarantee. And so to answer your question, I think the best approach is you ask other people you trust. You go to resources like the TLELs, GTLAs you trust. If necessary, you pay for people to kind of pre-screen. But at the end of the day, you need to be thinking about the end of the case, which for an expert is Dalbert and then live testimony, and work backwards. So however I find potential experts, when I am now vetting them, my conversations are not really about their resume or necessarily prior cases that may be fitting. I start with, tell me about every time you've been challenged, and if you've had to give live testimony or whatever. I may ask to read prior deposition transcripts or the reporting agencies involved so I can go do the research and see how they come across. I'm thinking about those risks now because under 702 and all the state analogs around it, trial courts, for better or for worse, I think for worse, are really using it to slam the door. So it's not just good enough to find someone on paper that fits. You need to be, even during the vetting stage, making sure that you think they can withstand scrutiny.
And how important is the balance between like a greenhorn expert who doesn't have testifying history and somebody who does? Like, how important is that experience for you? Because, like, to give you an example, I was actually talking to a seasoned insurance expert, Kevin Quinley. I think he's in the audience today, and he said that it's a chicken and egg situation because attorneys want you to have some experience, but till somebody hires you, there's no way you can get experience. So, like, from your perspective, like, how important is it for you that an expert has testifying experience?
Not very important at all is the most direct answer I can give. It's a consideration. It's a data point, one I ascribe some amount of weight, but I'll share the benefit of my experience trying cases, because experts are a critical component of a litigation file, but they're not everything, right? At the end of the day, you want to win for your clients based on the law and the facts. So there's a lot of components that go into it. So the best way to look through the lens is to pretend that you're a juror and put on the hat, right? Try and be as objective, in fact, as skeptical as possible about the whole case. What I have found, both from direct feedback from jurors on my cases and others that have been kind enough to speak with me, and also just what you can glean from jury verdicts, right, or body language in the courtroom, I have found that it's not quite an inverse relationship to the amount of testimony experience versus credibility, but there is some negative correlation there. So I think the starting premise should be, when the juror hears that they're your expert, they presume, and again, I think rightfully so from a presumption standpoint, that they must be slanted your way in some way. I mean, you're paying them money, they're giving an opinion, they're never going to be truly objective. It doesn't mean they won't listen and listen intently, but so they're already started against them. If they hear, like in most jurisdictions in discovery, in the formal investigation between each sides before trial, you can get access to how many times have you used this expert, how many times has he or she testified, how much money have you paid them in the last 3 years, whatever. What you'll find is that can be a tipping point to where they just don't even listen. And I think the defense, meaning the insurance defense industry at large, suffers from what I just call is like, you keep going back to the same well and drinking the same poisoned water. They wonder why some of these verdicts that they characterize as like nuclear verdicts or whatever happen. I think in part it's because the experts they keep parading in are so slanted in their favor. Even if they're not, just the data says, how could you not be if they've used you 100 times in 10 years and paid you $8.2 million? How could you not want to help the hand that feeds you? Now, does that mean you should go on the other side and, to your point, and say, hey, if I hire someone with no experience, there's risks with that too. But here's what I will tell you. The sooner you can demonstrate to a jury, and by that I mean an expert as a witness, the sooner an expert can demonstrate to a jury that they're a real person, they're not an actor, that although they're being paid, they're not being paid to testify, like in a particular way, they're being paid to give honest assessment, the better. And so strategically, sometimes I will deliberately not use somebody I've used before and try and find somebody else, including somebody who might not have a lot of testimony experience. Now, in my introduction, you mentioned the McDonald's hot chicken nugget burn case. The burn expert we used in that case, longtime MD medical provider, double board certified, critical care. He used to run the burn clinic at University of Florida Shands, and then he's now the statewide burn director. I'm talking about Dr. Joshua Carson. Shout out to him. When him and I started first working together, I don't believe, I may be mistaken, I don't think he had ever given a deposition. And if he had, it certainly wasn't a long list, and him and I, we had never worked together, and I don't think he'd ever given court testimony. So, I accomplished something I'm really proud of for a really deserving client in a very challenging case, in that McDonald's case, using arguably my most important witness as someone who had never done it before. And it showed in a positive way in the courtroom with his body language, with how conversational and not like stilted he was, right? He was willing to concede things that needed to be conceded. And he was also willing to draw the lines for the jury to say, this is really the universe that matters. When you ask me about these things, these don't matter, and here's why. So sometimes the less you've been in the Coliseum and in battle, the better you are, because you're just not as calloused and defensive,
Mm-hmm. So in these cases, like, how do you go about training these experts? Like, somebody's a greenhorn, so they don't have deposition experience. So do you help them prepare? I'm sure you do, but how do you go about it?
There's multiple stages of prepare. I don't want to connote the wrong thing here. I'm never telling an expert what to say. I don't even suggest how to say things. What I do is I try and tell them what to expect. Because if I can tell them what to expect, then they privately can prepare what's natural for them. And that's what I want. I don't need a paid mouthpiece. I don't need it. It'll never be persuasive. What I need is the person I hired to be themselves, but to be aware of the landmine. So I will prepare the expert up front, like right from when I retain them, if I know who the defense lawyer is or the firm, because I can get some historical data, right? If I do a little digging, I can tell them either from my personal experience or colleagues who have told me they're very aggressive, they're not very aggressive, whatever. Then after they complete their review, in most jurisdictions, even if not required, I want them to write a written report. I think there's a benefit both for me as the practitioner to read it and understand it. And also it helps steer their depositions and make them less wandering, and I think more nerve-wracking for the expert. Whereas if they have a report, they can almost see how the expert, the examiner's going. But I'll prepare them before they write a report from the standpoint of like, listen, remember what's at issue here. Again, I never tell them what to say. So just remember what I need from an issue standpoint. You're a liability expert. I don't need you to talk about damages, right? Unless they challenge your qualifications. I don't need 3 pages of you bolstering yourself, right? Just cut to the chase, explain what your opinion is, the method you chose to get there, and why you believe those methods are reliable based on the data you have. Nothing more, right? We don't need to hit a grand slam. I just need you to get on base here, get past that. So I'll talk to them before they write their report. Before their deposition, I spend maybe 15 minutes with them on a phone call, or at least preferably I would. By that time, I have a much better flavor of how the defense attorney is. They probably deposed a few witnesses, not the least of which my client. So I can kind of get a flavor for how they ask questions. That's what I'll kind of tell them. Basic things like, this person has a tendency to go the extra mile. This is going to take 4 hours. Not what should take an hour and a half might take 4, that kind of thing. And I'll give them some advice. Like, remember that this can be read, or, in my instance, I video record every deposition I take, especially experts, because I can play it at trial. So I tell them, it's as if you're talking to the jury. Just because it's an attorney asking the questions, you're always talking to a jury. So I give them those pointers. And then before trial is ironically when I spend the least amount of time preparing. That type of prep is more to calm their nerves. This is where the courthouse is. This is when you should arrive. This is, what will happen, calling you in and out. And I really defer to them. They're humans too. I have to remember that. So these people are often traveling away from their homes and family, their normal operation. They're spending a night in a hotel. They're probably nerve-wracking, right? It's nerve-wracking. What's the number one fear on earth? Public speaking. Just because I'm paying them for an opinion on paper necessarily doesn't mean that they're okay explaining it in public. So I try and calm their nerves and remind them that, they can't win my case. They can't lose my case, but they can lose credibility. And so just be themselves, that kind of stuff. So there's a few natural touch points to prepare them, but I am very much of the school of thought where less is more, meaning less hand-holding, less shepherding, and more just steering them to make sure they stay on course. But other than that, let them be themselves. And I think you get the best results that way.
Mm-hmm. So let's say that you are, like the defense counsel is somebody who's known to be aggressive with their cross-examination tactics. So in that case, like what tips or advice would you give your expert witness to how to go about tackling the aggressive cross-examination?
I would say anytime the examiner gets aggressive, make sure that the record will always look like they're the only aggressive voice in the room. It is totally natural to be defensive. We're humans. But you have to almost be unnaturally inhuman in how you respond to it, right? They may be very cutting. They're challenging your credentials. They're basically telling you're unqualified in so many words, or they're telling you're a bought and paid for opinion when you know you're not. It's so easy to want to defend your honor. I don't need anyone to defend their honor. So I always tell them, take a beat, like every single question, take a beat, take a breath, and think about how you would want a jury to hear it. Do you want the jury to think that that attorney's an asshole, or do you want them to think that you are? Because one of two is going to be the impression. And if they think you are as the witness, then the examining attorney did their job, right? They got under your skin enough to get that reaction. The other thing, though, is it's not always about attitude. Some of the best defense attorneys I've ever been up, the most skillful, they're very polite, professional, and that's great. That's how it should be. And yet they can extract very damaging information. And what I find is it's a matter of semantics and word choice often. So I will tell my experts in advance, be mindful for questions that contain absolutes. Never, always, right? These kinds of things. And when you hear those should be the red flags, not that they're trying to trick you, but just listen to the question, how it's framed. So when you give your answer, don't be so quick to yes or no. Feel free to explain. The third tip I generally give people when they're facing a tough examiner is to remember the deposition is almost rarely, unless something terrible happens and the expert's unavailable, it's not going to be the finished product, their final opportunity to talk to a jury. It may actually only be the record that exists for a judge to decide on a Daubert challenge or summary judgment. But when we go to trial, you're going to come in and start anew. And can a deposition be used for impeachment by prior inconsistent statement or something? Yes, but it's very rare with experts in my experience. So I always try and tell experts to calm them. You're not at trial in your deposition, even though it can be used for that. So take solace in knowing that you're not going to be given a platform. If the examiner is good, you're not going to be given a platform to tee up and present all of your favorable things. They're going to try and cabin you into the world of only negative things. That's okay. We can supplement your deposition with your report or an affidavit before summary judgment. You can come to a Daubert hearing and testify live in front of the court, right? Don't feel like this is your only opportunity. And I find that experts appreciate that when they realize, hey, it's not the end of the world if I don't say everything I came in planning to say. I can leave and know I still did a good job.
So let me just ask you another question. So once you have retained the expert, and there's obviously there's a time, the whole case schedule is there when there's a deadline to file the affidavit, and then the deposition deadline's coming up. So do you prefer a proactive expert who follows up with you about deadlines and coordinates, or do you prefer an easygoing one who follows your lead on the urgency?
That's a really good question. I haven't spent much time thinking about, but interestingly, I just feel like as a knee-jerk reaction, I have a very clear insight into this, which is I want the expert to be following up with me. Here's why. Experts and attorneys are both busy. We're both working on different caseloads, and sometimes with experts, particularly those in the medical field, this might only be 10, 20, 30% of their professional time. They're also having practice with patients, right? So to all extent possible that they can bother me, if that's even the right phrase, to say, hey, checking in, has the trial date changed? Has the deadline changed? Do you need me to review any other records? It's a friendly reminder. Look, I keep saying this, but I'm a person too. I've got a lot of obligations and responsibilities. You're never bothering me by being on the ball. The last thing we want is where I'm busy and I forget, you're busy and you forget, and now we're both scrambling against a deadline. Nobody's best work is done that way. So for me, and I think it's a preference thing, but as a relationship, I don't mind the expert at all following up and being diligent in that way.
So I think, we have a pretty good picture of your ideal expert witness by now, where you have clearly laid down what an expert should be like. So let's flip the coin and ask you about some of the red flags that indicate that an expert won't make a good witness for your case.
Sure.
What do you think some of those red flags are?
So there are a few, and these are, we're putting things in buckets, like umbrella categories, and there's nuance to all of this. But one of the things that just it sets me off is the experts who, I mean, they've done it a long time, sometimes decades, but it shows. That's the problem. Here's a very clear example that's happened twice to me that I can recount in my trials. The expert walks in the courtroom and he doesn't even need the bailiff, or she needs the bailiff to tell them where to go. They know where to go. They may say, "Hey, judge, nice to see you again," right? Something like that. It just sends the wrong message. And I think it's ego driven. And that's okay. We all have egos, but it needs to be checked at the door. They're there to do a job. And I think first impressions matter. And so that kind of, I'll say, informal approach to testimony really rubs me the wrong way. I don't like it. I feel like it puts me behind the 8 ball where the jury's already left with the wrong impression. Another thing is the know-it-alls. So the know-it-alls they get asked a question in a deposition, they've already answered it sufficiently, and then they go the extra step and start creating burdens for themselves they don't need to by citing literature, for example. Like, by the way, to all extent possible, if what you say is backed up by peer-reviewed literature, cite it in your report, and when it's relevant, bring it up in the depo. I'm talking about the things that are like, nobody's even asking you about it, and now you're almost self-bolstering. You're opening yourself up now. They're going to go pull that article. And it's impossible where those studies are direct one-for-ones. There might be relevant findings. There might be relevant, but who knows? What if the sample size was too small? Now you're just inviting things for a Dauber challenge that didn't need to be there. Another thing is like the experts who feel necessary to give opinions on every conceivable thing that they know about. Again, and I mentioned this earlier, as opposed to just staying on the path that I lay out for them. Again, not what to say, but what's important for me. So here's a consideration. This is just it's a real life example. If I have a patient with torn ligaments in their ankle, and they also have some post-traumatic arthritis in their knee joint, but I tell you in advance when I retain you, it's the ankle for me. You know, he hurt his neck, he hurt his lumbar spine, he hurt his knee. Even if a doctor and some other record claimed 1 or 2 of those were permanent, I'm not making a claim for that at trial. It's just an ankle tear for me case. So we just tried a case in Miami with that. Guy lost consciousness on the scene. For strategic reasons, we didn't pursue a TBI. Guy's right knee was hurt, had swelling. You know, we didn't really focus on it. It's just ankle. Now, put that case aside. If I go to a podiatrist or an orthopedic extremity specialist who focuses on ankle and foot, I don't want to see a report telling me about the post-traumatic arthritis in the knee unless it's truly relevant, right? Unless you're saying Mr. Redavid hired me on behalf of his client to find every orthopedic condition, because now you're opening it up, right? It's like, well, they're not even bringing a claim. So are you saying here, he's bothered by something? It just opens up a can of worms. And I know I'm giving one example with orthopedics, but it happens with engineers a lot. That, you know, I just want to know, is it more likely than not that this was the cause or contributing cause to the crash? And then I get a report sometimes where here's 18 different things in the differential, so to speak. All of them could have contributed. I did an analysis of all of them. It's like, wait a minute. Let the defense ask you these things. Don't just volunteer it. So being too loose-lipped, so to speak, with your intelligence and your opinions. And then I just think it's a matter of approach. And this one is very personal to me. I run a business at the end of the day. I'm in a customer service business. My customers are people who've been injured or killed, or so in that case, their family. A lot is at stake. There's a lot of negative energy already and stress that we have to manage. I don't need an expert giving me more stress. So to your point, a question ago, it doesn't give me stress when an expert's following up. That's fine. That's diligence. What gives me stress is this. I hire an expert. Yeah, I'll do the review. No problem. They're late by 60 days, right? Or they tell me they're going to get it by this date. I'm not talking about a day or two. I'm talking about they just ghost me for a while. That's stress I don't need. How about more stress I don't need? All of a sudden I get an invoice for $18,000 when I was never led to believe this was going to be more than like a $5,000 investment. And now I'm stuck. Right? The pricing thing in particular is a real thorn in my side. I have noticed that some experts more than others will take liberties of, I'm calling it overbilling, but even if they did the work, it's not reasonable to do that from one professional to another. If you feel like you need to go so far beyond the initial scope, give me a call and tell me, please. Don't just send me an invoice. That drives me crazy because then you're putting me in a bind. Those are the kinds of things that I just think are avoidable and should be avoided. And a lot of experts, I think, just don't think about those considerations. Maybe they're looking at it as, well, I've never worked with this person before. I don't know if they'll ever hire me again, so I'm going to skin them, so to speak. It's like, that's not the right approach, because the next time somebody asks me about it, and believe me, when you go in some of these forums and talk to colleagues, billing practices is top of the list. Nobody's looking for the cheapest. I've never seen someone say, who's the cheapest expert? Never been asked. But everyone will volunteer the people who bill egregiously. And those people, I don't think, get the future business.
I think that's a really key insight for everybody who's going to listen to this interview. Let's switch to experts knowing the law. So how important is for an expert to know the Daubert ruling or Rule 702 and the other rules of evidence that revolve around expert testimony?
I think it's essential on some base level. So there's a minimum expectation I have, but I don't expect anyone to be a legal scholar. I'm not one, so why should they? But there's a lot of distinctions here to draw. So, for example, a lot of the cases that we handle, although they're technically medical negligence cases, medical malpractice, if they happen in correctional facilities, jails, and prisons, we might bring claims, not just statutory, or common law medical negligence or wrongful death cases. We might bring constitutional claims under the 14th or the 8th Amendment to the U.S. Constitution, where the standard is deliberate indifference to serious medical needs. Was it a serious medical need? Was it objectively serious? Were you subjectively aware of it? And then did you deliberately ignore it? This is a legal standard. But when I go hire experts for liability, there's a lot of case on this. An expert can't just come in and say, I have an expert opinion that they're liable. Like in those words, like they were deliberately indifferent. Like when you use those hot buzzwords, courts understandably start looking at you sideways and you open yourself up needlessly to a Daubert challenge when you could use different, more common language. For example, instead of saying in a liability case, the correctional guard was deliberately indifferent to his needs, you could say the correctional guard made a report about it, which means he knew about it. I don't see any evidence that the correctional guard made a call or notified a supervisor, even though he was aware, right? There's ways you can explain the legal concept without using words. To your second point about knowing 702, the rule of evidence 702, or all the state companions, I think it's important to have an appreciation. There is an increasing trend. So Daubert's been around forever. The rule 702, I know it's about to be amended at the end of the year, but even still, the amendments are really just to clarify what was already supposed to be there. So people are generally aware of it. If they've even decided, even if they want to get into it, they always research, they find it. You don't need to know Daubert law, case law, and everything else, but you should know the concepts. Why? When you write your report, when you walk into a deposition, you should anticipate, look, the qualification prong of Daubert is an exceedingly low threshold to clear. And I will tell experts often, it's rarely in the Daubert challenge and not something you should worry about. Why? I have experts come in, they spend 10 minutes giving their credentials. It's like nobody's even challenging it. It's okay, right? But the methodology, the reliability, and all of that stuff is important to be aware of. So when you're giving answers, you're framing it in a light that, like, think about a judge reading it at a Daubert hearing or summary judgment hearing. They're reading it through that legal lens. So if you have some appreciation, that'll go a long way. But the other thing about the law is have an appreciation for how trials work. Look, in America, I can only speak statistics that I'm aware of. In America, almost every single civil case settles. Less than, I think, 2% go to trial. Do not get caught in the trap of thinking that won't be your case, even if you've been an expert for 10 years and you've never been to trial, because one day you will. And if you don't have some understanding of the dynamics of a courtroom, where people sit, where the jurors will be, how you're going to have to look, it can be very uncomfortable. And to be honest, you can just blow up on the stand. I've seen it. We had a defense expert implode. My partner, John, was doing cross-examination, and it was a very good one. But a lot of experts would have withstood it, took their blows, thrust and parry, and gone. This guy, I think, was so nervous, so uncomfortable. It had been so many years since he was in court. He started drawing lines in the sand that were so ridiculous. He ended up having to apologize in open court to our client for his opinions by the time cross was done, and they lost that case. So that, to me, although it was good questioning, good examination, the truth is it was really a very avoidable thing by an expert that I think got too comfortable thinking, at worst, I'll take a depo, they'll take my depo, but I'm never going to go to court. So have an appreciation for those things. And then I guess a related but still distinct topic is talk to your attorneys that retain you about specifically how questions might be asked in court and what's appropriate or what isn't. And here's what I mean. There's a gray area, even though there's law on it. It's very amorphous. What an expert can be a conduit of. So, for example, most witnesses can't come in and talk about hearsay statements made outside of court by someone who isn't here and all of that. But experts can rely on hearsay statements in rendering their opinions. So there's this weird dynamic, at least in my jurisdictions, where you can be giving opinions that are based on hearsay, But unless you're asked a very specific question, what is that thing you just said based on? And then you have to tell them, don't volunteer it, because you might walk into a hearsay objection that a judge who's maybe not as familiar with the law as he or she should be, or they're not paying as close attention, they might sustain an objection they shouldn't, that we could have avoided altogether if you just answered the question without stepping on those landmines, that kind of stuff.
And let's coming to pretty much the last segment of the interview today. So defense strategies that you may have seen where they are trying to limit or exclude your expert's testimony. Like, so are there like any go-to strategies that you've seen defense lawyers deploy, and how can experts counter them?
You saying that reminds me, Judge Barber, a federal district court judge in the Middle District of Florida, has an opinion, a random trial court order on Daubert, where he says something to the effect, like, it seems these days, like, to every practitioner, to every lawyer, every expert is a Daubert nail, and they have the Daubert hammer, and they want to. So to answer your question, and I cite that quote sometimes because it feels like that. It feels like every case I have an expert, there's a Daubert challenge coming, and I think there's a cost and a benefit to it, and the benefit is not always worth it for the defense bar. The cost is obviously they're billing the insurance company for the work. It's delaying the proceedings, which maybe they perceive as a benefit, but rarely is it. The true cost to me is when you're Dauberting, if you're a defense attorney, you're Dauberting a plaintiff's attorney where you know you have no business doing it. All you're really accomplishing is A, pissing off the judge who has to do more reading than they otherwise want, right? And B, you're foreshadowing 70% of your cross-examination, right? Even though you write to a judge in a Daubert motion, it's going to be similar concepts you cross-examine the expert on at trial. So now you basically put your cards on the table. So be confident that you really have a legitimate claim. The second tactic I see by defense attorneys is they're challenging every conceivable basis to strike someone. So you recall I just said earlier, at least in the 11th Circuit, the federal 11th Circuit in America, which covers Florida, Georgia, and Alabama, but this is based on Supreme Court precedent. The qualifications threshold for Daubert is so low. Almost anybody can be qualified. And yet I'll see 5 pages on qualifications. And I've had Daubert hearings. In fact, in that McDonald's case, there was a Daubert challenge to our engineer. I had hired an engineer to kind of recreate the kitchen, the McDonald's kitchen, in a lab environment and get nuggets and walk them through and find temperature and data, put that kind of thing. They Dauberted him on qualifications. And for the first time in my career, but I'm sure it happens every day across the country, the judge interrupted. This is the first argument defense counsel led with. The judge interrupted and basically said, "Are you fucking serious? You're saying this guy's unqualified to fry chicken in a basket and take temperature?" And he doubled down. "Yes, I am," and this and that. Know your audience, know the case. I think, and ultimately the whole challenge lost. And not that I'm saying it had any merit, but I think so. Like when you start with things that are frivolous, you've now lost. The other point about Daubert that I think is important is whether or not so this is the defense will file Daubert challenges, and then this is where I think the defense goes wrong. They file the Daubert challenge, then because we're the proponent of the expert, it's our burden to kind of satisfy 702. So it's up to the plaintiff's lawyer. You don't have to bring the witness live. I mean, if the court asks it, you will, but sometimes you could just say, "Here's a deposition. I'm sufficient. If you read this and read the law, it'll be good enough." Then what happens is the defense just kind of rolls over to whatever defers to our preference. So if we don't call the expert, they just go to the hearing. And if we call the expert, if I'm a defense lawyer and I think the plaintiff is trying to put junk science or nonsensical opinions in front of the jury, I'm not letting them survive Daubert without the expert coming. I'm telling the judge, no, I want the Daubert challenge. Yeah, it's their burden, but nothing says I can't bring this expert. Fly him or her in, get him or her ass on a Zoom screen. You need to see this, right? Because I think you lose persuasiveness when you write this 25, 30-page thing, and the plaintiff, although they write a nice response, we always treat it very seriously. We're trying to protect the integrity of the expert as well. If I'm like, "Judge, you don't even need to hear from this person live. It's such a nonsensical motion." Think about the message that we're conveying then about the defense argument. And I don't think the defense bar is as flexible, and in the moment, they just think, "I filed the motion, I've done my part." And I think and I never hire anybody I don't think will survive a Daubert challenge, so I welcome it. But I think if you're not forcing the plaintiff's lawyer to bring the expert, then how serious are you?
Mm-hmm. So As a follow-on question, a lot of times experts experts would order their own profiles with us, and then when we would tell them about all the challenges that were there against their testimony, and we keep telling experts that a Daubert challenge is not a bad thing per se. An unsuccessful Daubert challenge against your testimony is actually a great thing, because now you can use it to tell people that you have survived a Daubert challenge. But a lot of times what happens is experts are not aware that their testimony has been challenged under Daubert in a prior case, and the challenge may have been unsuccessful, but the expert never gets to know, because maybe the attorney has not communicated it to them, maybe the attorney has not involved them in preparing the response for the challenge. So do you have a suggestion for such experts, as as an expert, should I be following up with you that, hey, Jordan, was there a Daubert challenge in my case? Or do you proactively inform the expert? And what if the attorney is not doing that?
This is a really fascinating topic, really fascinating. And I have, feels like a universe of experience in every different way experts has approached this. The most direct answer to your question is, I think experts should err on the side of follow up with the attorney to make sure you're aware if a challenge has been filed and what the outcome was, and ask for copies of the orders, like the filings and the orders. Two, this is just a matter of practice for us in my firm, so I can't speak for everybody else, but we are very deliberate about telling an expert, hey, they just filed the Daubert challenge. Here's a copy. Let's talk about it. There are experts I have worked with and actually continue to work with in large part because of how involved and how invested they are in their own reputation. So here's an example. There's a physiatrist who's board certified in brain injury medicine in Florida, and I'm probably offending him if he were to listen to this, because I'm oversimplifying what he does. But he can, among other things, put together a life care plan for the future. So he talks to all the providers, they tell them what care they need, and he looks at it. He can look at and project the cost of it and whatever. This is a man who doesn't get Dauberted a lot, but he's been doing it 20, 30 years, so he's been Dauberted a bunch. He has his own lawyer, which may be a little extra, but he has his own personal lawyer that when a Daubert challenge is filed, that lawyer consults with us. And they don't step on toes. They just, can you give me a prize? Can I see your draft of the response before? Right. This is an expert who's so invested in his reputation. By the way, he's never had a successful Daubert challenge against him. And you know who he tells that? Every defense lawyer in every deposition. And he does it very delicately, but it will come up with, experience, and you've testified before. Yeah, I've testified 120 times, and I've successfully defended 87 Daubert. I'm making up the number now, but I think that's okay. What is really bad, and I have the experience that I've been able to weaponize for my client's benefit, it's fair game, are the experts who are either willfully ignorant or just otherwise ignorant. They don't know. They don't ask. They don't follow up. And I'll find through services just like yours, prior successful Daubert challenges, even in part, right? It happens, as you know, where a federal court will be like, look, he or she stepped a little out of their lane. They can't say this, but 90% they can go forward. And then you'll get to them in another case, and has a court ever limited your testimony at all? No, I don't think so. And then you bring it up. I wasn't even aware of that. And then it can spiral very quickly, because now you want to talk about defense mechanisms. They're caught with their pants down. So there is no downside to being aware of it. And I think if you were to draw analogies like to any other profession on earth, if you're going to invest the time and ask people to pay you money for it, and this is going to be part of the way that you earn a living and provide a service to people in your community, then you should invest enough in yourself to at least be aware. You may not need to get personal counsel to review it, but have some tracking mechanism, because ultimately it's to your benefit, so that people can't come to services like yours, which are amazing, get the benefit of this data, and then weaponize it against you when there's no, it's a free strike against them when I shouldn't even have the opportunity to throw the pitch,
All right. Well, this has been amazing, Jordan. Thank you so much for all the insights that you brought today. I mean, we have a few questions from the audience, but before we go to that, let me just ask you, is there a question that you would want me to ask you?
Oh, man. No, don't do that to me. The audience has heard me blab. No, let's first of all, thank you for having me. It means a lot. I think this is a really important topic. So many things about what I do day in, day out are important to the clients I serve. But this topic in particular, the interplay between litigation attorneys and the experts that are used on both sides of the aisle, is so important and not projected into the community enough, the significance of it, that I'm just happy you gave me the platform. So if there's some questions, I'm definitely happy to answer them.
The pleasure was all mine. So I'll go to the first question. So this is it's about, as to the expert who was disqualified due to Daubert. This is the time that you had retained an expert and he was Dauberted, and you had gotten him through a referral agency. So the question is, did that have anything to do with the expert coming from a referral agency, and could he or she have been struck unrelated of how the expert came to you?
Good question. The answer is no. It was not the agency's fault at all. And candidly, I'm aware of the court's ruling, and I'm an officer of the court, so I followed it. But I exhausted all appellate rights, not out of pride, out of principle. The ruling to strike was wrong. I told that to the agency, and I told that to the expert, who was devastated. I mean, this is a very important case, given the stakes. And I can just tell you that the court's ruling was essentially that his methodology was unreliable because he relied in part on peer-reviewed studies that involved animal testing. And the whole point was, Judge, we don't test pregnant women. We don't give them poison and then see how human babies come out. Of course we test animals, because there had been the exact mycotoxin from the particular mold we found in a study that I believe it was with pigs, I want to say, caused the exact condition, renal agenesis. It was a direct one-for-one. Exposure to this in utero, statistically significant increase in the chance of renal agenesis. And the court's entire ruling almost hinged on, well, they've never tested a human before, so it's unreliable. The second part of the ruling that bothered me was he has a private practice. I say bothered me because it didn't jive with the law. He had a private practice where, among other things, he would help people with infertility problems. And given his specialty, it's totally within his... And the court commented on that extensively in the Daubert ruling, even though the ruling had nothing to do with his qualifications. And it felt like you can't say he's qualified and his methods are unreliable and then give me 2-3 pages about his qualifications. And in fact, the first panel of the appellate court that affirmed the trial court's, what I believe to be an erroneous ruling, when I filed the motion for a hearing and I pointed that out, they scrapped their whole opinion, the appellate court, and wrote a brand new one, still affirming in the trial court's favor against me, but kind of implicitly recognizing something wasn't right. So the short answer to the question is no, it wasn't the agency's fault, but it wasn't the expert's fault either.
Mm-hmm. The next question is that, do you recommend a mock cross-examination as a testimony prep technique?
It depends on the case. So the only times where I have been very deliberate about, hey, let's set up a mock environment, let's go through it a few times, are cases where either A, I anticipate the examination will start on one day and go into the next. I think that's a very awkward, unnatural thing. And so there's some strategy in terms of how to prepare for that, and if, to the extent that you can control when certain things are elicited or not. The other thing is, if an expert asks me to do it, and they may not know, they may not be experienced enough to say, can you run me through a mock cross? But you can pick up on it. When they start saying things like, so what exactly do you think they're going to ask me? Various questions like that. I will absolutely do them the courtesy of saying, hey, why don't we set some time aside, even if it's 15, 20 minutes, and I'm going to cover what I would do. Because in any of those situations, covering direct examination is so insignificant. That's a natural conversation. They already know what their opinions are. Cross is very easy for me too. I read through everything scrupulously like I'm a defense attorney, and so I do the best defense attorney job I can. And so, yeah, I will give them that, but I don't view it as a necessity in every case, especially for the people that have not expressed discomfort talking in front of people.
Mm-hmm. And the next question, the last question, is actually a follow-up to that. It's connected. That when the hiring attorney is not helping prepare you for testimony, so the expert wants help, but the hiring attorney is not helping. So what's your recommendation for the expert in that case?
That would be a big red flag for future business, but it doesn't solve the problem then and there. I would be bordering on insistent to get the mock examination. And if you can't, you might actually want to spend money and find another attorney who will. And I mean, quite literally, go to the marketplace, find a plaintiff's attorney firm or defense firm that's completely unconnected with the case. But if it's a plaintiff attorney that hired you, maybe hiring a plaintiff's attorney makes sense, and say, look, can I give you my depo and my report? I've got a trial coming up in 2 months. I want somebody's subjective take on my weaknesses. Give me this and run through and give me feedback. There's nothing prohibiting that. But I would say at all costs, if you're uncomfortable enough where you feel like a mock examination is necessary for you to prepare and the attorney that's retained you is unwilling to give it, go to the marketplace and get it and then bill that attorney for it originally.
Mm-hmm. All right. I think that makes a lot of sense. I'm pretty sure the expert who's asking it will also find it very helpful. So I think that wraps up all the questions. So thank you once again, Jordan, for your time today. And thank you to everyone who took out the time from their schedules to attend and go, and spend the time with us today. We'll be back with another guest very soon. And so please feel free to reach out to me if you want to be a guest on a webinar, or if you'd want us to cover some topic, or if there's a guest that you'd want to hear from. And if you want to contact Jordan, why don't you share your contact details and your website with the audience?
Sure, appreciate it. So our firm website is yourchampions.com. My email is jordan@yourchampions.com. But you can find us on almost every social media outlet on either Jordan on Justice as a handle or the On Justice podcast, because we have our own podcast. So I'm happy to help anybody out there and even answer questions. This is a good for the goose, good for the gander, rising tides lift all boats kind of situation. I don't care plaintiff or defense. The truth is, when cases are worked up and handled properly by all the
So there you have it. So thanks a lot, Jordan, and hopefully we'll do this again soon.
Well, thanks again for having me. Have a great day, everyone. Thanks for tuning in.
Yeah, thanks a lot. Bye-bye.